And Ms. Reisinger, I'd like you to, when we go live, I'd like you to go ahead and announce the case name and who you represent. Ms. Reisinger, and also the cause number.
Yes, Your Honor.
Go ahead.
We're here on cause number DC 2000760. Plaintiffs are Ben Medina and Louis Elliott versus Southwest Freight Distributors, Inc., DBA Southwest International Freight Services, Inc. et al. Versus third-party defendants Donald Ray Williams, Endars, and Rudd. Your Honor,
Wait, let me hear the defendants, who the defendants are here for.
Your Honor, Matthew Ford on behalf of Defendant Southwest Freight Distributors, Inc. and Defendant Smith, also third-party plaintiffs herein.
John Godoy for third-party defendant Darsam Taylor.
And Dina Roderick for third-party defendant Donald Ray Williams.
Let's proceed. Oh, go ahead.
Yes, Your Honor. And if I didn't already say, my name is Alex Reisinger. I'm present for the plaintiffs. This case arises out of an incident in October of 2018 where an 18-wheeler craned backwards into a vehicle in which Mr. Medina and Mr. Elliott were passengers. In this case, there is a notice of corporate representative for Southwest Freight entities on limited topics that was agreed to for June 11th, 2020, back in April 22nd of 2020. So we noticed in April for dates well in the future. In the in-between time, after plaintiffs noticed the deposition of this corporate representative, there were two new parties that were added as of May 15th, 2020. Which some of you might hear and say, well, Alex, isn't that unreasonable that there's new parties and then they want to quash and get more time, which is what's represented in Southwest's motion to quash the deposition. Your Honor, the reality is, and I don't think that Mr. Godoy or Ms. Roderick will disagree based on the emails that I have, and I'm happy to screen share them for the court. Both parties agreed to proceed. On June 11th, even though they were new to this case on the limited topics for corporate representative. They'd agreed to that on June 8th. And then on June 9th, Mr. Ford filed a motion to quash asserting these other parties' rights as the basis. Now, Your Honor, we since that time, since this all has happened on around June 11th, there's a discussion of providing new dates in September, as as a statute of limitation runs in October and our designation deadline is in October. That's just too far away. And for that reason, Your Honor, we have moved to compel the deposition to proceed within the next 30 days. And Your Honor, I'd also like to briefly make a comment on an issue that was raised in a third party's response to our motion to compel. In the third party defendants, and I think that was filed by Mr. Godoy, response, there's the issue raised about having the ability to renotice the corporate representative on different topics. And there's been some emails going back and forth between all parties raising the issue, of Mr. Ford not wishing to provide the corporate representative for a subsequent deposition. First of all, Your Honor, as long as the topics are separate, there's no requirement that all parties put together all of their topics in one go. That would unnecessarily make it so plaintiff is subject and held captive by all the other parties on their discovery plan, which is inappropriate. Further, Your Honor, if necessary, I have pulled a case that I think is right on point out of the Court of Appeals in Austin, where if there was a subsequent deposition, and in this case, there was actually the exact same deposition notice for the corporate rep, so same corporate rep notice twice, and the court still on mandamus vacated the trial court's quash of that corporate rep deposition, stating the correct thing to do is to look at it on an unduly burdensome analysis and find if there is an easier way to make things happen, which under Zoom, which is how plaintiff wants to take this deposition, is what we want to do. I don't see how that would be possible. I don't think that there's any water held under those assertions. So for that reason, Your Honor, we ask that that deposition be ordered to go forward within the next 30 days.
Mr. Ford.
Your Honor, may it please the court. Defendant Southwest has no problem with providing their corporate representative within the next 30 days. And in fact, provided availability dates in their motion to quash for June 24th and June 25th. The genesis of Southwest's motion is that Originally, these depositions were noticed before third-party defendants were brought into this lawsuit. And the third-party defendants in this lawsuit, Judge, are the driver of plaintiffs who, frankly, plaintiffs should have sued because of the police report. The police report finds the plaintiff's driver as being a contributing factor to this accident. But unfortunately, plaintiffs didn't sue them, so it left it up to me to do that. And so I brought them in, and they didn't appear until after these notices were issued. In fact, Ms. Roderick, who represents the alleged entrustor of that vehicle, and Mr. Williams, who was driving that vehicle, didn't receive the corporate representative's notice until days before. I want to say 3 days before the notice deposition. So I tried my hardest in order to get some dates to not make this a hearing about let's pull out our calendars because we're all big boys and girls and can get these rescheduled. But unfortunately, being a staff counselor, a former staff counselor, I understand that Ms. Roderick and Mr. Godoy are dealing with a very jam-packed docket. And so I've proposed dealing with their calendar and making my corporate rep available at that point in time.
Mr. Ford, but didn't Ms. Reisinger said that they had already agreed to this June 11th date? Is that not accurate?
That is accurate. I agreed to.
Then why did you quash it then?
Because the third-party defendants had not appeared at that point in time, and then there was talk about reproducing corporate rep.
But if they agreed to the June 11th date, then why didn't you withdraw your motion to quash? That was the only basis for it, right?
Say that again, I'm sorry.
So as I understand the history here, the third-party defendants who were newly added agreed to this date, but despite that, you filed a motion to quash, and then even after knowing that they had agreed to it, you didn't withdraw the motion to quash. Is that accurate or not?
They agreed subject to the understanding of being able to renotice the corporate representative for another deposition. So my thought was, let's get everybody caught up in this case.
Mr. Ford, okay. All right. So I get what's going on. I'm going to order this to appear. Mr. Godoy, did you want to say something?
Just a little context, Your Honor. My client and also Ms. Roderick's client, we timely filed answers on May 15th. So the deposition was scheduled for June 11th. We get the notices on the 8th. On the 8th or 9th, 10th, I basically email everybody and say, I might need to depose the corporate rep on different issues at a later date. But we're going to let the June 11th depots go forward because we want Ms. Reisinger to address any limitations issues. And so there's always been a dispute between me and Mr. Ford's clients about whether the corporate rep could be deposed again on underlying different issues at a later date, not the same issues. So I kind of have two issues that I want to just put before the court. I'd like to incorporate language in the order that says the corporate rep can be deposed again on different issues at a later date. And also with respect to when the deposition must be completed, I'm hoping to get a little bit more than 30 days from today, Your Honor. I'm going to be on vacation the first couple weeks-ish of July. Limitations expires on October 25th of 2020. If we got the deposition done by mid-August, that would still give plaintiff about 60 days to get a new petition on file and get service. And so those are my two issues, Your Honor.
Ms. Reisinger?
Yeah, Your Honor, and I'm not trying to be difficult and not to have to show my hand or my legal strategy in this case, but with lining up the deposition to discovery, that's simply not enough time. And I would make myself available or the clients available on weekends or after hours if necessary, so we can get this done on these limited topics. So
Mr. Godoy, I'm sorry, Ms. Reisinger, go ahead.
No, I'm happy to try to compromise, but mid-August, if something like this happens again, is simply not enough time because I've already been burned once on agreeing to put a depot out far in advance. I asked back in April, all the way for June, fine. And I understand that that's not what discussion Mr. Godoy is part of. But if this happens again and I keep on having this problem, that's my big concern. So I would be willing to accommodate in any way I can to make that possible.
Mr. Godoy, when is your vacation?
The core dates are the 2nd through the 10th, Your Honor. Obviously, I'd prefer not to be in depositions the afternoon of the 1st or even the morning of the 1st, Your Honor.
So anytime after the 10th then would work.
Correct. I mean, maybe, can we have until the end of July? I'm really trying to be respectful of Ms. Reisinger's interests. 2.5 months should be sufficient, Your Honor, to kind of, get a new petition on file and service.
I understand that. I understand Ms. Reisinger's concern also with, I can see how she would feel burned in this, that I still don't understand quite why Mr. Ford quashed this. And of course, the quash wasn't within 3 days. It didn't automatically stay the deposition. So as I understand the notice, when the notice went out. So I'm going to order this to occur within the next 30 days. And I'm going to include in it that if any third party, now this, Ms. Reisinger, you need to include anything you want to depose the corporate rep on in this. So you need to take your full corporate rep deposition, but if Mr. Godoy, and I'm sorry, I don't remember the other person's name because they haven't spoken, but if they also, the two new third-party defendants, if they need to take a deposition in the future, they're able to do that.
Thank you, Your Honor.
All right. Do we have anything else?
That's all from plaintiffs, Your Honor.
So you're going to give me a new order for that, Ms. Reisinger?
Yes, Your Honor.
Go ahead and email that to my court coordinator as well as e-file it. Ms. Roderick, did you want to say anything, Ms. Roderick?
No, Your Honor.
Okay. Then your client will also have the opportunity with Mr. Godoy if you needed to do a new corporate rep deposition. If you need to, try not to. I'm not trying to do 2 depositions, but given what's going on, I understand why there might need to be one.
Thank you, Your Honor.
All right, guys, anything else?
No, Your
No,
Honor,
Your
are we
Honor.
excused?
You are excused. Just give me that order as soon as you can, okay?
Yes, Your Honor.
Thank you. Okay, so we still have Mr. Davis. What are you here for?
Your Honor, we had a slight scheduling conflict with each other on a new scheduling order for the trial setting that got moved from June, more than 180 days out to January. And the defense proposed one scheduling order. I proposed a different one. Mr. Pauly was kind enough to give us what the uniform order would look like, and I'm good with the uniform order.
What case is this on? What's the cause number?
I'm sorry, McCowan, Your Honor.
Cause number?
Delta Charlie 18-04143.
And when is this set for trial currently?
January 12th, I believe. 12th.
And then what, and you want it when?
No, we agreed in June because of COVID, we were going to move it to January. I'd suggested even June of next year to be sure we could preferentially try it before yourself and this honorable court. And then all it was scheduling order to put new deadlines in place because a number of parties had been dismissed and, the cases reconfigured some. And I said, I want to do a new designation of experts. And Mr. Campbell sent out one that said, no, experts are frozen. And I said, I won't agree to experts being frozen. I'm just saying, let's just get a new order. And I'd actually proposed to designate by June 30th, but this was weeks ago at this point. And so it has been set before the court. We were unable to reach an agreement. But Mr. Pauly pointed out that under the court's uniform scheduling order, the party seeking relief should designate experts by September 30th and the defense by October 14th. And so I'm good with the uniform scheduling order that comes out of this court. I think we actually contacted the court's coordinator or clerk, and they said, y'all need to put one together and get it back to us. And so we were unable to get one together and put it back to you.
Okay, and your opposing counsel here is Mr. Pauly.
Mr. Pauly and Mr. Ryan.
All right, you're going to need to you need to unmute Mr. Pauly.
That better?
Yeah.
Much better.
Your Honor, I agree with Mr. Davis in principle that the uniform scheduling order is fine. except for a couple of things. And the primary thing is designating experts. This case is well over 2 years old. It's 2.5 years old at least. And we've deposed 6 plaintiffs experts so far. We have 2 more to go. And there's 1 defense expert, 1 expert designated by a defendant who's been dismissed, that plaintiff wants to convert into a plaintiff's expert that needs to be deposed as well. And so I don't see any reason for reopening expert discovery at this point in time. That's the first one. And then the other one, I'm sure Mr. Davis and I haven't talked about it. We could probably agree on it. But objections to expert testimony under the court's uniform scheduling order would be December 5th. But what with Christmas and New Year's coming in there, that becomes kind of an unworkable day for getting a hearing in an adequate amount of time before the trial setting. So we proposed November 20th for that day, just because it's before Thanksgiving. Gives everybody an extra 2 weeks.
Mr. Ryan?
Your Honor, I don't have much to add to what Mr. Pauly says, other than parties have already invested a fair amount of time and energy in deposing all liability and causation experts of the plaintiff. The case has not been reconfigured in any meaningful way as to the remaining defendants. The same experts that plaintiff designated apply to all of the remaining defendants, and there's not a reason to reopen this and cause an unnecessary additional quantum of labor when the case is essentially prepared for trial, other than a few more depositions of remaining experts. So I would second what Mr. Pauly said. Let's keep the deadlines that have passed and move forward with the final preparation as was planned before COVID came down on us.
Mr. Davis?
Once again, Your Honor, the case has been reconfigured. The plaintiff's theories of liability and as to which defendants have been changed. As the court knows, in Dallas County, experts have to give written reports, which they get questioned on at length. And is this all your opinions? Have you written every single thought down? And if you have any other thoughts, please give them, get them out. So all I'm saying is we have dismissed a number of parties. The case is reconfigured, it's focused, and I would like the opportunity to have my folks hone their opinions to what is going to before the trial court. So I think it's just gamesmanship from the defense to say, well, we've done all this work. Well, we've all done a lot of work. These are big cases. We're all big boys and we do a lot of work. And that's not the end of the work.
Yeah, I'm actually offended by this gamesmanship crack, because all of the experts have been deposed after, or the majority of these experts have been deposed after mediation, after plaintiffs dismissed about 6 or 8 different defendants. They had time to hone their arguments.
So what exactly is the dispute here? Is that you don't want him to be able to designate new experts, or what exactly are we fighting over right here? I'm not, everyone seems to agree that we need to depose the remaining experts.
Right.
What still needs to happen?
I'm sorry for stepping on you, Your Honor. We're opposed to designating any new experts. And what has happened, Your Honor, is there was a deposition on written questions sent to a company called Mobile X USA, which apparently goes around to nursing homes, picks up lab samples, and then sends them off to labs for testing. That deposition on written questions came back in April of 2019, and it fell through the cracks. Nobody, not on the plaintiff side, nobody on the defendant side, nobody looked at that until my expert internist looked at it right before his deposition. And one of the disputes in this case is that my client, Dr. Leach, and Casey Campbell's client, Dr. Doppelapudi, did not order a B1 lab test for Mr. Davis's client, when in fact the lab test was part of this Mobile X USA deposition on written questions. His experts had it. He sent it to all of his experts. They didn't mention it at their depositions. Now Mr. Davis wants to come back and have an expert on the validity of this particular lab test, even though It's been in his hands since April 26, 2019.
I'll respond, Your Honor.
Okay.
That lab test existed in a set of records that slipped through, and I challenge Mr. Pauly to say that, including his own client, didn't know he admitted he did not order the test. Dr. Leach said, I didn't order the test. Dr. Doplaputi said, I requested the test. It was up to Dr. Leach to order the test. And in her own notes says lab value B1 pending, okay? This was a big deal because part of my prepared cross-examination of Mr. Pauly's client is, hey, there is no B1 test. Look at the person you're the expert for says there isn't one. Look at the other co-defendant who said there isn't one. And you know what? He's right. Mobile X was produced by
Dr. He.
Dr. He, who is dismissed. And as the court may remember, this is a Wernicke's encephalopathy, which is a B1 thiamine deficiency case. I mean, this is an injury resulting from thiamine deficiency. And it materially changed the case. But now they've gotten all my experts to say no B1. You agree they're B1. I mean, they pinned him in a corner. And I think Mr. Pauly, while he's offended with gamesmanship, I'm equally offended with somehow it's my fault. My experts missed it. Everybody else's experts missed it. Every defendant missed it. And this materially changes the facts. And so we just need to, but my folks are now committed to written opinions that they have been questioned on and pounded on, that this is all their opinions. These are true opinions. This is their opinion. And it's just absolutely set up for impeachment. So that's why I want a chance for the experts to analyze this and say, how does this affect their opinion, if any? I mean, some people, if they were just quiet, it may actually change my expert's opinion, but you know.
So are you, Mr. Davis, so I want to make sure I'm kind of understanding the dispute here. So what you're wanting is the opportunity to designate a new expert and for all of the experts who've already been deposed to change their expert designation to incorporate this new information?
Yes, and how it may apply.
Well, Your Honor, that if I may,
Sure.
there is not new information here. This was information that was available to all parties. To allow the plaintiff to reshuffle the deck when he had information that came, I believe this test result was produced with the exhibits attached to the deposition of one of his experts named Dr. Gavi, Benny Gavi. So, there is not new information that would justify reopening designations. I suppose if, and I'm speaking only for myself off the cuff, not for Mr. Pauly or Mr. Campbell, but if Mr. Davis wants to have his experts, the ones that he's already designated, recant their other testimony and supplement their opinions, to me, that seems probably fair based upon the configuration as it's now known. But to reopen designations seems inappropriate in the context of information, whether it was recognized or not, was known and accessible to every single expert.
So let me ask this. So how many of the defendant's experts have been deposed? Just one, is that right?
No, sir. No, Your Honor. I think there's only one or two remaining to be deposed.
Okay, so how many have been deposed?
There have been six plaintiffs' experts have been deposed and two remain to be done.
How many defense experts?
Let me look.
I think Dr. Landon was the only one.
Dr. Ladden has been deposed. Dr. Lakritz has been deposed.
Okay, Dr. Lakritz is a neuropsychologist responding to a neuropsychology report. liability wise, Judge, it is Dr. Landon and Dr. Landon only. And
Well, Judge, we had the expert internist, Dr. Medellin, scheduled for deposition, and he's the one that discovered this lab result in the Mobile X records. And I, out of courtesy, informed Mr. Davis of this before the deposition took place, so that he wouldn't be surprised, because it was a surprise to me. It was a surprise to my client. It was a surprise to every other defendant, as far as I know. And so that deposition got postponed while plaintiff's attorneys had the chance to assimilate the information. So it wasn't like we haven't been moving on this case. It was done.
So what I'm trying to figure out, it sounds like both sides were, I'm not sure, I don't quite understand the history, but both sides were surprised by this, that this test had actually been done, I guess. And one expert was able to figure that out before the deposition, and that was incorporated into his opinions were able to change and were incorporated into that deposition. There was another defense expert that got moved, I guess, because of this newly kind of discovered evidence. Is that right, Mr. Pauly?
That's correct, Your Honor.
Okay. So I'm guessing, Mr. Pauly, why, I guess I'm kind of always of the view, what's good for the goose is good for the gander. Your expert was able to have his deposition rescheduled to be able to incorporate this new information. Why shouldn't the plaintiffs have an opportunity? If everyone was kind of surprised by this and hadn't realized this, why shouldn't the plaintiff also have the same opportunity?
Well, Your Honor, first of all, my expert's deposition was moved because, out of courtesy, I informed the plaintiff that this test existed when we all believed that it hadn't. And I don't have a problem really with Dr. Gavi, Dr. Adamoklian, the neurologist. If they want to change their opinions based upon the fact that this test exists and they've now had a chance to look at it, all well and good. What I'm opposed to is opening the door for all kinds of new experts. If based on newly discovered evidence, although it really isn't newly discovered, but evidence that we're newly aware of, the experts' opinions have changed, so be it. But why bring in 2 more experts or 3 more experts to opine on the report when it's been in everybody's possession all along?
Mr. Davis, that's a good question. Why do you need new experts? Why can't you just, I agree with Mr. Pauly that I think that you should be able to edit or update or amend your expert designations. And if they want to depose your experts again on these new designations, I think they should be allowed to. But why do you need new experts? Why can't the existing experts testify to this?
well, some can and some may not be. We need to be able to put this in the blender and figure out how it changes causation. And, you know, the court is well aware, as I've been through hundreds of trials. What's going to happen is no matter what the motion in limine says, do not go there that this expert wrote this opinion all the way back to their Chapter 74s. And that's one of the other things is, Your Honor, the expert reports that were produced in agreement, save and except Dr. Gavi, that they were Chapter 74s so that we could all go to mediation and be frustrated. Okay, so Dr. He's lawyer and one of the surgeon's lawyer were pushing to get this to mediation so that we could figure out how to get the case resolved. There was a lot of pre-mediation discussions, and they said, we got to have reports. And I said, okay, I'll do the Chapter 74 because the expenses were getting outrageous already. But I said, I'll do the Chapter 74 expert reports for the purpose of mediation.
Mr. Davis, I don't think you're answering my question, but so let's get to the point.
Well, it's the backlog of the report they're being questioned on was a Chapter 74 before defendants, you know, a lot of the experts Chapter 74 report. So before they had the benefit of rewriting a report due to testimony.
Mr.
And
Davis,
now-
you need to get to the point. Either you're not answering my question.
I think I need the opportunity and protection to know that Dr. Gavi can change his opinions, Dr. Ademalikin can change his opinions, or whether Dr. Ademalikin is so harmed based on the cross-examination that will have to be part of a motion in limine that it's better off to get a new expert on the causation side.
But as I understand it, both the plaintiffs and defense experts thought, except for this most recent one, thought that this test didn't exist. So
Correct.
wouldn't they have the same issue that you do? Doesn't your experts have the same issues that their experts did? Because I
Well-
assume that even that one expert discovered it prior to the deposition, obviously had done a report that it said that this test didn't exist, right?
No, actually, his report said it did exist, and that's, I said, you're the only expert that says this. Are you sure you're right? And he said, yeah, I'm sure, and called me back the next day and said, yeah, I found it.
Okay.
But I'm in the position of my client not representing and not remembering this patient at all and going by the chart. And this report wasn't in the chart where it was supposed to be. It was just in the lab's own internal documentation. So if Dr. Gavi is going to be changing his testimony, Dr. Leach, my client, is going to have the same opportunity to recant the fact that he didn't order the test based upon a document that was incomplete.
And for a brief clarification on that, Your Honor, and I apologize. The Mobile X was ordered as a big block of records from Dr. He's counsel, who took lead on ordering records. The results in the Mobile X were not contained in the skilled nursing Windsor Garden records. It didn't exist. Both Dr. Leach and Dr. Doppelputi admit it doesn't exist in the records. This Mobile X was just I think there was 14 or 15 sets of records dumped over as a supplementation of records that frankly everybody missed, all the lawyers.
Mr. Davis, I'm sorry. What I'm going to do, I'm going to allow all the experts who need to amend their reports to incorporate this information. I'm not going to allow, you haven't been able to explain to me why you need a new expert. And so I'm not going to allow any new experts at this point. Does that cover all of the issues that we have? Can you guys work out dates on this?
We can get the rest of it worked out, Your Honor, I believe.
Okay, so everyone else, and also every expert that changes their opinion is allowed to be redeposed on those changed opinions. So if the plaintiffs, if they have 3 experts that change their opinions, they can be redeposed. All of the depositions, just because this comes up, as long as we're in this period of social distancing, will be deposed remotely unless the parties all agree that it will be in person. So I don't want any fights about, I want to be able to attend this deposition in person, and they're saying no, they will all be done remotely unless the parties all agree to the contrary. All right, anything else, guys?
No, sir.
Not for me, Your Honor.
All right, just give me so you can get a new scheduling order on this. We already have the new trial setting. It sounds like we just need a new scheduling order, right?
Yes, sir.
That's correct.
Great, guys. Thank you. And you guys are
Thanks, guys.
excused. You have a great week and you be safe out there, okay?
You too.
Your Honor, you too.
All right, thank you. Oops. So do we have the next hearing ready? Do we have anyone here on the PS versus Anderson Homes Dallas LLC case?
Yes, Your Honor. I'm having a little bit of technical difficulties this morning. Can you hear me?
I can.
Okay, awesome. Yes, I'm here on behalf of plaintiff for the motion for entry of default.
There's someone here that says Spencer's iPad. Who is that?
That's not mine.
Sir, you need to unmute. Sir, what are you here for, sir?
I'm a party to a different case that I'm represented by Mr. Toby.
You're a party?
Yes, Your Honor.
Let me just see. In what case are you here for? We have this morning the PS case and the Barron case. Are you here for one of those two cases?
No, Your Honor. I'm here for a case. It's Albert versus Bank of New York and Carrington.
I don't think that's set for today. What time did you think it was set for?
I had it for 10 a.m. Central Time for today. Is today the 22nd? Do I have the right date?
Yeah, today is the 22nd.
Okay, that's what I had. Now, I could have been misinformed, possibly.
Why don't you do this? Call my court coordinator. Her number is 214-653-6510. And if you could ask her kind of what's the status of your case. I don't see that on the docket today. The one you're talking, the Albert case, whatever that is. I don't have that on the docket. And so it may be another name or something else, but ask her when this is set for hearing or trial or whatever. And then if you need to get back on here, you can. Okay.
Okay. So I'm sorry, Your Honor, the number again is
214-653-6510.
653-6510. I'll call her right now, Your Honor. Thank you.
Oh, I'm sorry. That hearing was canceled, sir. I just got a message. The hearing was canceled. So, yeah, the hearing was canceled.
Okay. All right. So I don't need to call in then, Your Honor. Just I can talk to my lawyer, Mr. Toby.
Yeah, just talk to your lawyer, and then if there's any questions, I can call my court coordinator.
All right. Thank you, Your Honor. I'll sign out then. Thank you, sir.
And okay, thank you. And so let me ask the interns real quick. Did you guys get for the SMU and UNT interns, did you guys get the link for the lunch today?
Yes.
Yes, Stephanie, Alexa.
Yes, Judge Hoffman.
Okay, we're having some problems with this. All right, so did anyone not get one from the SMU and UNT interns? Anybody not get it? Okay. All right, so there's a gentleman here named Shane E. Could you put your full name on the screen?
Yes, sir. I'm actually not sure how I can enter my full name, but I can let me take a look. This is the first time I'm doing it over my phone. I apologize. I was under the impression we're doing I'm on Zoom. I apologize on my phone. Meeting settings. Okay, maybe that's what I rename. Here we go. Sorry about that. Okay.
And are you plaintiff's counsel in that case?
Yes, sir. I'm actually covering for Michael Ritchie from my firm. He's on the pleadings, but I will be appearing on behalf of plaintiff today.
Okay. Tony, are you there? Tony?
I'm
Tony,
here.
are you there?
I'm
Okay.
here. Sorry.
Let's go on the record on cause number DC 203-832, Pios versus Anderson Homes Dallas LLC. Counsel, make your appearance.
My name is Shane Egball on behalf of the plaintiff, Your Honor.
Okay, let's go ahead and proceed.
Okay, so Your Honor, this morning, actually, I came to my attention that defendants, so this motion is moving for default as to liability against American Real Estate Investments, Real Deal Advisors, J. Tyler Wine, and John Larson, all defendants. And it came to my attention that American Real Estate Investments LLC actually answered this morning, as well as John Larson. So the only two remaining defendants we have not heard from are Real Deal Advisors, Inc. and J. Tyler Wine. We'd like to go ahead and get an entry of default as to those defendants. The returns of service, the action was filed on March 6th, 2020. Obviously, their answer became due shortly thereafter. They missed the deadline, and the returns of service have been on file since for over 10 days. Since
when were these two defendants served?
They were served via substituted service from an order of this court on May 6th, Your Honor.
May 6th, okay. Go ahead.
Yes, they were served on May 6th. So their answer was due, I believe, at 10 a.m. on Monday, June 1st. They failed to answer. They still haven't appeared to this day. And again, their returns of service have been on file for over 10 days, since June 8th. And so default judgment as to those defendants is proper.
Okay. Go ahead.
So we're moving for, I guess we filed the proposed order as well. So we would just want the court to grant the entry of default, and then I guess set a hearing at a later date to determine damages.
Okay, but the order you submitted included all four defendants, or I don't even see an order attached. Is the order attached to the actual default judgment, or where is the order?
My understanding is that the proposed order was filed at the same time that the default judgment was filed. I think it's on the docket as well. I apologize because I was planning on coming in. I didn't realize until this morning that it was going to be a Zoom hearing, so I was going to have a copy for Your Honor. However, I'm happy to file an amended one that only refers to those specific individual defendants that have not answered. As soon as we get off the hearing today, I can have my office file a proposed order setting forth those two defendants.
Okay, that's fine. Yeah, go ahead and do that. Go ahead and email my coordinator about that. And Rhonda,
okay.
Once he emails that to you, just put that on my chair. I'll be in tomorrow. So, all right. Anything else?
That'll do it, Your Honor. Just default judgment as to liability for those two defendants that have not answered. I can email that to your coordinator right after we get off the call.
Great. All right. Thank you so much.
Thank you very much. You have a nice day, Your Honor.
You too.
Bye-bye.
Let's see. There we go. All right, let me turn off YouTube.